My name is Ellen Burge with Venable, and I wanted to welcome you to the 2021 Payments Law Virtual Boot Camp. This is brought to you by Venable and MAC, the Merchant Acquirers Committee. I'm an attorney in the payments group at Venable and also co-chair of MAC's Government Relations Committee, and we're very excited to have, this is now the third event of this kind lined up for you starting today. We started this series as a payments law symposium in 2019. We were in person in Washington, D.C., and it was a great event. Of course, last year, things being the way they were, we had to move virtual, and so we did our event last year virtually, and this year we've got a somewhat briefer event for you to keep the tradition going. But our boot camp here, 3 sessions today, tomorrow, and Thursday to cover things and payments and what we've been working on and what we're seeing, and have you hear from a lot of our colleagues in this space. So, mark your calendars. We'd like to do this again in person next year. We have done this within the first week or 2 of June. The date will be announced, but we are very glad that you joined us today. I'm going to briefly turn it over to my partner, Evan Mintzberg. Evan is going to give you all just a quick preview of the week. If you can join us every day, same time, same place for the next 3 days, we've got a really great lineup. So Evan, why don't I pass it to you, and if you could just preview that would be wonderful. Thanks.
Great, thanks, Ellen. So kicking it off today, the first panel is the regulatory road ahead, discussing developments in DC, including changes in leadership and priorities at the CFPB and FTC, as well as other regulatory updates affecting payments companies. Tomorrow, Ellen and Andrew Biggert will be presenting navigating high-risk industries, including gaming, subscription sales, cannabis, telemarketing, and more, together with Brian Jones of Merrick Bank. And then finally, on Thursday, I'll be moderating a panel on popular and evolving payments business models that will include a discussion of business to consumer and distribution payments, marketplaces, and buy now, pay later models. And I'll be joined by my colleague Andy Arculin, as well as Nicole Ibbotson of Incom and Dan Chandry of MindBody.
Okay, let's go to Andrew. He's going to introduce today's panel, and then we'll get going.
Great. Thank you, Ellen. I'm Andrew Biggert. I'm a partner here at Venable, where I work with Ellen and Evan and our other colleagues in the payments group. And I've got the easiest job today. I'm just here to introduce the next panel, which is the regulatory road ahead. And I'm going to turn it over right now to get it started to our partner, Len Gordon, and he can introduce his all-star cast and get this going. So thanks, everybody, for joining.
Thanks, guys. You guys did a wonderful job putting this together. I'm Len Gordon. I'm a partner in the Advertising and Payments Group in Venable's New York office. We do have an all-star cast today. I am joined by my partner and friend, Allison Baker, who helps lead our consumer financial services practice, by Kim Ford, who is the Senior Vice President for Government Relations at Fiserv, and by Scott Talbot, the Senior Vice President of Government Affairs at the Electronic Transactions Association. Today, we're going to be covering the regulatory road ahead. I'll be talking about issues at the FTC, Allison at the CFPB, Kim will be talking about some cybersecurity issues, and Scott will be talking about what's going on the Hill, especially regarding new forms of currency. So I'll get started. We've done enough introducing. So in thinking about the regulatory road ahead, it's, I think, important to look backwards. So in 1914, the FTC was created. In 1938, it was given the power to prohibit unfair, deceptive acts or practices. And it did that through administrative litigation before an ALJ at the FTC, which could then be appealed to the Commission and ultimately to courts of appeals. In 1973, Section 13B was added to the FTC Act as part of the Trans-Alaska Pipeline Act. The purpose of that statute was to give the FTC the ability to get a preliminary injunction while an administrative proceeding was pending. It also provided at the very end, and what's referred to as a second proviso, that in proper cases, the Commission may seek, and after proper proof, the court may issue a permanent injunction. In 1975, Sections 5L and Section 19 were added to the FTC Act. Section 5L provided that the FTC could get penalties for violations of cease and desist orders, as well as mandatory injunctions and such other and further equitable relief as appropriate. And Section 19 provided for the ability for the FTC to obtain relief necessary to provide redress to consumers in two instances. One, where there was a rule violation, and two, if a cease and desist order out of administrative litigation had been issued and the FTC convinced the court that the conduct was such that a reasonable man would have known that the conduct was dishonest or fraudulent, and that relief was subject to a 3-year statute of limitations. And for the first several years after Section 13B was enacted and Section 19 was enacted, they proceeded as intended, though the FTC did not make that much use of Section 19. In the late 1970s and early 1980s, lawyers at the FTC were frustrated with the cumbersome practice that they had to follow to use Section 19. So they creatively decided to try and test the waters and see if they could convince courts that the grant in 13B of the right to obtain a permanent injunction encompassed all forms of equitable monetary relief, including equitable monetary relief. And they picked their cases carefully with, very bad facts, and bad facts make bad law. And courts began to accept this view of broad implied equitable remedies, and it was consistent with some prior Supreme Court jurisprudence. Ultimately, it became the default enforcement mechanism for the FTC, and the FTC grew ever more aggressive. It would claim that the proper measure of equitable monetary relief was gross proceeds. It initially used that measure in what they would term fraud cases, but it came to be applied in most routine false advertising cases. And of particular importance to the payments industry, the FTC began to impose this draconian relief jointly and severally, so that a payments company which may have made a $500,000 on fees income for processing payments would be on the hook jointly and severally for the entire processing volume for which it had processed, which would essentially be the net proceeds that went to the merchants that were processing and alleged to have violated the FTC Act. And this, from the 80s until about 2 years ago, the FTC was very successful. Defendants would challenge it, and the FTC was undefeated. But last year, one judge on the Ninth Circuit, a panel on the Seventh Circuit, and a panel on the Third Circuit said, wait a minute, the statute says injunction. It doesn't say all this draconian monetary relief. And the court started acting accordingly. And ultimately, there was a circuit split. Two circuits saying the relief is not as the FTC has deemed it. And the Ninth Circuit, sort of, at least one judge there saying, we really ought to look at this again. So it ended up in the Supreme Court in a case involving AMG and its principal, Scott Tucker. Bad facts, an alleged payday lender, at least very serious allegations, also criminal case in parallel. Ultimately, the Supreme Court on April 22nd ruled in favor of the defendants. They said that the grant in Section 13B of the right to obtain a permanent injunction did not come with the full suite of equitable remedies. If Congress had meant to do that, the court found it would have so stated the way it did in Section 5L. It based its decision on the plain language of the statute. It looked at the purpose of Section 13B, which was for situations where a defendant was violating or about to violate. It is a forward-looking statute, not a backward-looking statute providing for compensation. It also noted that Congress had explicitly provided a means for monetary relief in Sections 5L and Sections 19, so there was no reason to infer it here. The court used some, Justice Breyer, writing for a unanimous court, used some colorful language. He said to find that the grant of injunction would provide this type of broad, equitable monetary relief would allow a small tail to wag a large dog, and that statutes should not be interpreted to find elephants in mouse holes. The FTC raised a host of policy arguments, which the court rejected and said you should take those to Congress. And so in a unanimous decision, the court found that Section 13B does not provide the FTC with equitable monetary relief, which has thrown cases in litigation into a tizzy. It has made everyone who's involved in FTC investigations rethink what a proper resolution of those is. Really has changed the future of the FTC. So now what? Well, the FTC is lobbying Capitol Hill hard to fix, in their words, the error of the Supreme Court. Others would say they are seeking to have this authority that they now want for the first time. There has been a bill introduced in the House by Representative Cardenas. It is now out of the subcommittee and reported to the full Committee of Energy and Commerce, which has jurisdiction over the FTC. It would restore the FTC's ability to get equitable monetary relief. It would apply a 10-year statute of limitations. Importantly, for those cases that are in litigation, it would apply retroactively. It also would make clear that the provision applies not just to ongoing conduct, but to past conduct. Whether that ultimately gets out of the House, so far it's been treated on cleanly partisan lines. And all they need in the House is a simple majority. It appears it will be a standalone bill, so it would need 60 votes in the Senate to get past the filibuster. I am not capable of predicting what's going to happen in the Senate. There is lots of action there and lots of moving pieces, but the U.S. Chamber of Commerce has been lobbying for limits on the FTC's authority, a scienter requirement, such as in Section 19. There are questions about really whether it's fair to apply it retroactively. So we'll have to see, but the FTC is pushing hard, very hard, for Congress to fix this. Whether it does so and exactly what it does remains to be seen. So what else is the FTC doing to deal with this gap in its authority? It's doing several things. It's partnering with states and trying to leverage the enforcement authority of various states. The FTC is making aggressive use of their authority under Section 19 and finding rule violations where they probably wouldn't have brought those cases before. For example, the Restore Online Shoppers Confidence Act, although a statute provides that it is to be treated as a rule for purposes of Section 19. So earlier this week, the FTC brought a case against MoviePass with a really aggressive interpretation of ROSCA. ROSCA traditionally has been thought of as a negative option statute, and the FTC is used to challenge negative options here. The statute is being used really to challenge more the disclosure of the underlying offer. I think you'll see more aggressive use of any statute or rule that the FTC can find to try and use its monetary authority under Section 19. There have been talk of doing additional rulemaking. Commissioner Chopra, who's still at the FTC, has been arguing both on the competition and the consumer protection side for the FTC to do rulemaking, which would allow it to get civil penalties or Section 19 relief for such violations. I think you'll see the FTC referring more cases to its federal law enforcement partners, the Consumer Financial Protection Bureau or the Department of Justice. And there has been talk again by Commissioner Chopra, who thinks sort of aggressively about these issues, to start using the FTC's civil penalty authority. The FTC has a unique ability to sue one person for violating a cease and desist order issued in administrative litigation against another person, provided it can show the non-party had actual notice and actual knowledge of the prior cease and desist order, and it can seek civil penalties for that up to $43,000 per violation. So, again, that's something else I think the FTC is looking at. Looking forward, there's also changes underway, at least potentially, at the helm of the FTC. Rebecca Slaughter is serving as the acting chairwoman. It is not clear whether she will get the permanent job. A few weeks ago, those of you who follow antitrust matters may have seen there was something of a fiasco involving 7-Eleven's acquisition of Speedway convenience stores. Staff had negotiated a resolution to deal with concerns about geographies where the merged entity would control a very high number of convenience stores / gas stations. The parties had entered as a timing agreement, as you would expect in a merger, and the merger was set up for confirmation by the commissioners, and the commissioners deadlocked. The two Republican commissioners supported it. The two Democratic commissioners, from what we can tell, wanted more draconian relief. It stayed there for a while, and ultimately the parties just closed the transaction. They consummated the merger. They've indicated that they're intending to honor their commitment to divest certain stores, but that hasn't happened yet. And so all the FTC did is send out competing press releases from the Democratic and Republican commissioners, and the merger was allowed to consummate. Senator Lee from Utah sent a scathing letter to the FTC complaining of its gross incompetence in that matter. Whether that has a lasting effect on whether Commissioner Slaughter or acting Chairwoman Slaughter becomes Chair Slaughter remains to be seen. Rohit Chopra is still at the FTC. He is continued to be a staunch and very vigorous advocate for very strong consumer protection remedies, including very strong views on individual liability and making sure that any monetary relief hurts. He is awaiting confirmation to the CFPB, but that has still not happened in the Senate. That's a little bit tied up. President Biden has nominated another commissioner to fill former Chair Simon's spot. It's Lena Khan. She is incredibly young. She's in her 30s. She is a prodigy, a very widely published antitrust scholar, very tough on big tech, noted critic of Amazon. You could expect that she'll be very strong on both consumer protection and antitrust issues, and will, I think, sort of take over Commissioner Chopra's mantle. What else can we expect at the FTC? Obviously, it will depend on who the chair is, but everyone I've spoken to there says that there's certainly an increased focus on protecting minorities, and that takes several views. There's increased outreach to minority communities to make sure that those communities report fraud, deception, unfair conduct. There's a sense that that kind of conduct is underreported by minority communities for a variety of reasons. You will likely to see more cases under the Equal Credit Opportunity Act by the FTC, and in looking at other cases, trying to ascertain whether people of color or other minorities are being disproportionately affected by alleged unfair or deceptive practices. One of the other things I think that you're going to see out of the FTC, and we've already started to see it, is a focus on dark patterns. They held a workshop on dark patterns about a month ago. They're going to issue a report. Some of you may be wondering what dark patterns are, what constitutes a dark pattern. According to the FTC, it's sort of the engineering of a website or a disclosure to deceive consumers, so that the disclosure is there, but the website allegedly is created in such a way that consumers' attention is diverted from it. There are a lot of folks who have concerns that that standard is highly subjective. So we'll see what comes out of the FTC's report, but the statement by former Justice Stewart about obscenity, he knows it when he sees it. It reminds me of sort of the FTC's approach to dark patterns. So that's it for the FTC. With that, I am going to turn it over to my colleague, Allison. If you have questions, we'll try and get to them either at the end. I think we'll save a little bit of time for that. And with that, I will turn it over to Allison. Thank you.
Thank you, Len. Good afternoon. I'm Allison Baker, Chair of Venable's Financial Services Practice, and I wanted to speak a little bit about the Consumer Financial Protection Bureau today. What we're seeing, what we're expecting, and I kind of want to do a little bit of a framework and almost a historic framework, just to give everyone a sense of really how significant this moment in the CFPB's history is going to be. July 21st, 2021, the CFPB will turn 10 years old. Dodd-Frank is, of course, 11 years old that day, but the CFPB is 10 years old. And when the CFPB came online 10 years ago, there were a lot of questions and concerns about whether or not it would exist, how long it would continue to exist, whether or not there would be effective legislation or other activities to either get rid of it altogether, consolidate it into the FTC or another agency. These were real conversations that were being had. I was at the Bureau 10 years ago, and people were talking about these things outside, not at the Bureau, but outside the Bureau. And there was real question about whether or not the Bureau would be able to use all of the authorities and powers that had been given to it under Title 10 of the Dodd-Frank Act, which is the Consumer Financial Protection Act, the CFPB's enabling statute, as undoubtedly most of you know. And what we've seen in the last 10 years is that has obviously not come to pass. And the CFPB is a very formidable agency in Washington. It is one to be reckoned with. It has continued to recruit and in many cases retain very talented staff who really come from the whole scope of financial services activities, from being economists to being auditors to being accountants to, of course, being lawyers. And it's a long way of saying that at the time when the Bureau was created 10 years ago, none of this was being taken for granted. And the reason I bring this up is because the nominee, the apparent nominee and apparent, assuming Rohit Chopra gets confirmed, he'll be director. Rohit Chopra was on the ground 10 years ago when the CFPB was created, and he was the first student loan ombudsperson. And so he has in his, DNA, if you will, kind of the origins of the CFPB and kind of the concerns that really greeted the agency when it was first founded. And I almost articulate those concerns as existential threats. So when Rich Cordray became the first ever CFPB confirmed director, of course, he was confirmed in an intra-session recess of Congress. His confirmation was subsequently rendered unconstitutional. It was subsequently redone. And he was really, kind of formally came online a couple of years after the CFPB was actually created. And if you recall, there was a lot of political hullabaloo around that. And all of this is a long way of saying that the difference between what we saw 10 years ago when Rich Cordray took over the CFPB and what we're going to see today soon when, Rohit Chopra is expected to get confirmed is night and day. At the time that Cordray took over the CFPB, there was a real concern about, as I said, its existential existence. Would it continue to exist? What were some of the things that the Bureau needed to do to kind of justify its existence, to kind of make friends, if you will, with other stakeholders in the financial services space? There were some unusual, interactions that the agency had with other state agencies, with other federal agencies. None of it was a given that a lot of these things would all be in place like they are now. And the reason I bring that up is because I think what you're going to see when Rohit Chopra comes in, inevitably, is you're going to see not only the vigor and the enthusiasm and the energy that animated Rich Cordray's tenure at the Bureau. You're going to see all of that, but you're also going to see a renewed commitment to kind of enabling the full authority of the CFPB without any of the accompanying concerns or existential threats that were present really at the beginning of its time. There isn't going to be a question in common conversation about whether the CFPB will be around in 5 years, or how it's going to interact with the OCC, or how it's going to interact with the FTC, or what its role is going to be vis-a-vis the state attorneys general. Those issues have kind of resolved themselves. And so what you're going to see now is a very invigorated group of people who are at the CFPB. You're going to see a very invigorated director. You're going to see a very invigorated administration. So I should note that the founder of the CFPB, Elizabeth Warren, a lot of Elizabeth Warren's people, for lack of a better way to describe it, people who she's either mentored or whose career she's helped to nurture, or people who were former staff members of hers when she's been in the Senate now for a while. A lot of those individuals have made their way into different offices in the Biden administration. And so a lot of the ideas that kind of gave birth to the CFPB have taken flight in other places as well. So the CFPB is going to really have what I almost think of as a kind of a 2.0 or a renaissance of sorts, because now you've got all of its ideas firmly implanted, a lot of the questions around its existence kind of going away, and a lot of the same energy and vigor and engagement that really, kind of was a characteristic of the agency at its birth 10 years ago. So what does that mean as a practical matter? I think it means a few things. First of all, I think that out of the gate, the CFPB and the acting director has already made this clear, have some very real priorities around COVID and the pandemic. If you are engaged in the offering or provision of a consumer financial service or product, especially one that touches any component of the credit continuum, whether it's offering credit, servicing credit, collecting on credit, furnishing, or reporting, you are likely subject or potentially subject to increased scrutiny around how consumers were treated during the pandemic. And there's, of course, very specific rules on the books in various states and municipalities. There's the CARES Act, but there's the CFPB's unfair, deceptive, or abusive acts or practices authority, which is really quite extensive and it's really quite broad. And there's no doubt that the CFPB is going to, in fact, it's already started to use that UDAP authority to look very carefully at how these actors along the credit continuum have interacted with and interfaced with consumers who have in many cases been devastated or hit very hard by the pandemic and the economic circumstances around the pandemic. So out of the gate, I think that is the number one priority for any director, whether it's Rohit Chopra or someone else, although presumably it will be Mr. Chopra. Number two, as Len was talking about equity and issues around equity, that is, of course, a very critical part of the CFPB's agenda as well. And anyone who knows the history of the Bureau and kind of some of its core building blocks knows that its commitment to issues around equity, particularly for communities of color, that issue has long animated a lot of the work that the CFPB does, not just its fair lending work, but other component parts of the agency as well. And I think you're going to see a renewed and in many ways a more explicit commitment to that. And what that means in a practical matter is really a few things. First of all, the Office of Fair Lending, which had been moved to the director's office during the Mulvaney and Kraninger years, has already been moved back to share space with the Supervision, Enforcement, and Fair Lending offices, the so-called CEFL unit of the CFPB. So fair lending is once again going to be looking at cases that are potential enforcement actions. It's going to once again be very engaged with supervision for examining for compliance with the Equal Credit Opportunity Act and other component parts of the fair lending jurisdiction and infrastructure. You're also going to see, I think, a renewed interest in what's called fair servicing, not just fair lending, but fair servicing, and how fairly are individuals in certain communities being treated kind of along the whole credit continuum. Some of that will overlap with the COVID inquiry, and some of that is kind of apart and separate from it. I also think what you're going to see a renewed interest in is access to credit. And this is one of the things that's very, one of the tensions inherent in the CFPB is that the CFPB is charged with enforcing the consumer finance laws. It's charged with creating regulatory structures that protect consumers. But when you protect consumers and you create a lot of regulatory infrastructure, you also create barriers to entry to markets, which in many ways sometimes reduces competition, which in turn can limit the access to credit or access and opportunities that lots of different groups of individuals or communities have. And I think that this tension between how much regulation do you put in and how much access to new products and services do you allow is one that's going to continue to animate the Bureau for a number of years. And I think you're going to see that conversation. And it's been part of the CFPB's kind of dialectic, if you will, for a really long time. It's been there since day one. But I think you're going to see that conversation take flight in a little bit of a different way in the Biden administration along lines of equity. It's all fine and good to say that we care about access to credit, but if we're not really allowing new and novel products and services to come onto the market, if we're not truly democratizing our payment systems, our banking systems, then are we really living up to that idea of enabling access to credit, which of course is a way of furthering one of the CFPB's missions of equity. And I think that conversation, which of course is well underway and has been going on for years, is really going to be manifest at the CFPB, not only in its offices of supervision and RMR, which is its policy arm, but markets being the policy part of that. But I also think you'll see it kind of throughout the Bureau. It will permeate a lot of different decision points that the CFPB has to make around how it deploys its enforcement tool, how it deploys its examination tool. So that's another thing that I'm looking at. The third issue that I think is really kind of a really critical public policy issue, and to Len's point about, if you look at some of the positions Mr. Chopra's taken as commissioner of the FTC, you'll see this is really kind of an examination of the role that the technology sector has played and continues to play in financial services. There's a lot of conversation, as you all likely know, about whether or not fintech companies, financial services companies that aren't banks, that are largely technology driven, have been subjected to the same levels of regulatory scrutiny as banks, even when some of those companies offer similar types of banking products. And banks themselves have said, well, it seems like they haven't been. And I think that the CFPB is going to spend a fair amount of energy examining that question and really asking themselves, are we holding non-bank financial technology companies to the same types of rigor and scrutiny that banks have long been held to, largely because banks are subjected to all kinds of different prudential regulatory obligations to which non-banks are not. And I think you're going to see that concept, that issue really permeate and become a priority for the new director at the CFPB, because that seems to be mission critical, which is this kind of idea of using regulatory infrastructure to so-called level the playing field among those entities that are regulated. So I think those are the three really big things we're going to see. I think in terms of, some of the other things that I'm just watching, this kind of common phrase that I keep hearing is, personnel is policy. I think at the CFPB, personnel is policy. And what you've seen is the CFPB kind of cast a very wide net in recruitment. It's really been trying to actively recruit lawyers and others to join its forces, supervision, enforcement in particular. And I think that effort means that the Bureau's in kind of ramping itself up to be much more active than it has been in recent years. I note, though, that as the Bureau gets more active, you are not going to see a recession in state activity. So the states, especially some of the attorneys general and some of the regulatory offices, the banking commission offices in California and New York Department of Financial Services, were extraordinarily active during the Craniger tenure and the Mulvaney tenure, in part because they perceived, correctly or not, that the Bureau was less active. That activity in the states is not going away. What you're going to have is a much more collaborative and probably coordinated effort with the CFPB, and the Bureau is going to be kind of leading the charge. And one more point I want to make, and I'd be remiss if I didn't mention this, which is the impact of AMG, which was what Len was talking about. So the AMG Supreme Court case that came down recently, that basically makes it impossible for the Federal Trade Commission to recoup restitution except in certain circumstances, means that in many cases, you're going to see certain types of financial services, consumer protection cases automatically go to the CFPB. As many people know, the Bureau and the FTC share non-bank jurisdiction, not only as to products and services, but as to certain laws, including the Fair Credit Reporting Act, for example, the Fair Debt Collection Practices Act, et cetera. And you're going to see the Bureau, perhaps, I expect, take perhaps what would be a larger share of those cases than in the ordinary time when the FTC kind of has its regular, unfettered, unquestioned restitution authority. So I think that coupled with all these other points is going to make the CFPB a very active participant in the consumer protection and financial services space, along enforcement, along examinations and supervision, and also just generally in terms of policy. And it's really something we're looking at very carefully and watching very carefully as we, expect over the next several months those policies are going to take flight. So that's kind of what we're predicting and what we're seeing for the Bureau. I'm going to turn the mic back to Len. Thank you for the opportunity.
Thanks, Allison. That was great. Before I forget, for those of you who need CLE, the password is regulatory, all caps, 2021. Again, regulatory 2021. I'd now like to introduce Kimberly Ford, the Senior Vice President of Government Relations at Fiserv, who's going to talk to you about cybersecurity and all kinds of cool stuff. Kimberly?
Well, we'll see about whether it's cool or not, but thanks so much. And happy to be with you all today. So it's been interesting. We were kind of brainstorming about some of the topics to bring up. And as you all, can imagine, there are no shortage of issues in the payments sector and broader financial services market. But we thought we would focus at least on cybersecurity to start. And then Scott's also going to talk about what I would call the other hot topics. So between cybersecurity and things like cryptocurrency, those are really, taking up a lot of attention here in Washington, D.C. And, maybe just a quick level set. I mean, I feel like, for one thing, we used to call cybersecurity data security. And then somewhere along the way, a couple of years ago, we started calling it cybersecurity. I think they're somewhat similar, but, it's not a new issue, of course, for payments, right? I mean, we've always known that the security of our systems is essentially, at least, for service providers vendors like Fiserv, it's our currency, right? I mean, you know, a data breach could spell the end of one of our companies in terms of just the reputational damage alone. So of course we've taken security of our systems very, very, very seriously. And I think when you look back at least the legal framework around, you know, data security, it really, you know, started, I would say, probably back in 2001 when California passed a data breach notification law. And that, but it wasn't really talked about until about 2004 when there was a breach of a data aggregator company in Georgia called ChoicePoint. And that triggered that California law. And then all of a sudden, all these states kind of tripped over themselves to enact these data breach notification laws. And at that time, you know, 2004, 2005, 2006, you know, the real focus was on what to do after a breach, right? How you notify, whom you notify, when you notify. But there wasn't as much discussion around what you do to prevent that breach in the first place. And it's fascinating to me because even, you know, all these years later, it feels like we're just now kind of getting around to this question of what you should do to prevent the breach in the first place. You know, in the meantime, obviously the financial services sector has not waited to be told by government what we should do to protect our systems, right? I mean, lots of us, you know, had already had baseline, you know, cyber protocols and, you know, kind of the standard, you know, only provide access to the employees who need it, and, you know, change your passwords, and, you know, watch out for the things like jump drives, and, you know, how you're securing your data in transit and at rest. But from, you know, again, a regulatory standpoint, we've still, even after all these years, only seen maybe, I think it's over a dozen, maybe less than 20 states that have ever put data safeguard laws in place, you know, that actually specify, you know, baseline security protocols that businesses should have to protect data. Then we had a couple years ago, the New York Department of Financial Services passed a cybersecurity law, and that got, I think, a lot of folks' attention. And again, I think, you know, our view at that time was it still codified a lot of the things that financial services had already been doing, you know, for several years. And during President Obama's tenure, we did see a real focus at the federal level on cybersecurity, right? And that's where I think that term cybersecurity seemed to make it more into the lexicon or the mainstream verbiage of you know, at least Congress and their staff on the Hill. And, you know, what we saw under President Obama was an executive order saying that, you know, government cards had to have EMV chips as one protective mechanism, but he also established the cyber framework, which he gave authority to NIST, the National Institute of Standards and Technology, to create and maintain. And they have done so over the years and continually updated that cyber framework. So I say all that because, again, you know, this is not a new issue. But what I'm seeing right now in the market that I think is maybe a change is if you look at the super high profile SolarWinds breach and the extent, you know, the breadth of government agencies and private companies that impacted. Of course, that got folks' attention. Now you've seen the Colonial Pipeline breach. You've seen now it spill over into, you know, meat packing. So the point is that now it's like everyday lives of Americans are being impacted by these, you know, ransomware and cyber attacks. And that feels a little new. Again, you know, when you had the high profile retail breaches over the years, of course you could make an argument that affected a lot of Americans, and it did. But, you know, when it comes to, you know, payment card breaches, for the most part, we know that consumers are made whole. So it may be a momentary pain, but, you know, that's resolved you know, in most cases relatively quickly. But these other things, you know, gas prices jumping up, you know, the inability to maybe buy the meat you want at the grocery store. I mean, that's, you know, that starts to get into a whole different level of a pain point, if you will, for some Americans. And so I think what you know, we can make of that is that, for one thing, different members of Congress are certainly paying attention. And we're seeing, for instance, like the Senate Intelligence Committee that's starting to, you know, think about, should there be some, you know, different kind of, you know, mid-incident notification of a cyber attack or ransomware type of incident that would not just be limited to, a typical data breach like we've seen in financial services for years, but these much more far-reaching notifications. I think what's interesting about that is obviously, again, the financial services sector already are familiar with breaches and notifying bank regulators of things like that. But as you start to pull in the intelligence committee, that can be tricky because the intelligence committees, by their training and by design, don't share a lot of information. So as you think about like who should be the owner of these types of requirements, or who should receive these types of notifications besides Joe Q Public, should it be Intel? Should it be the Cybersecurity Agency, CISA, at the federal government? Should it be Department of Homeland Security? It starts getting into some very real questions. And I think what that means also for those of us in financial services is we've had this history, for years, again, dating back to President Obama's tenure, where essentially you had the critical infrastructure sectors, financial services being one of those. We were able to really work with our regulator, i.e. Treasury, to come up with financial services specific plans, processes, notifications that, again, were really tailored to financial institutions, service providers, payment processors, et cetera. What I think we're seeing now, because of the nature of, how many more lives are affected in these kind of day-to-day ways, is that we may see a shift to where there's no longer this, sector specific approach, but everything gets thrown in the pot together. And so that's, I think what we all need to be paying attention to and watching is, the processes that we have had in financial services for years that other industry sectors have not had. Are we going to have to change these kind of tried and true mechanisms because now we're all going to be painted with this one size fits all cybersecurity approach? Will we still get to retain, our specific processes? Will the notifications change? And then again, who's going to kind of hold all this data? Will it be, will we go out from Treasury and into like the national security apparatus, which could mean CIA, it could mean Department of Homeland Security, it could mean the National Security Agency, any combination thereof. So again, while I think it's sometimes easy to just say cybersecurity, we got that, we've been dealing with that for years, I think we do need to be paying attention to how these new really high profile attacks may change the security protocols, the processes, and potentially the notifications for those of us in the financial services sector. So Lynn, I'll pause there so that we can get to our other speaker.
Kim, thanks. That was great. Thank you so much. Last but certainly not least, Mr. Talbot from ETA. Scott, take it away.
Sure. I just wish Kim had a little more energy and excitement about payments. Just really, try to pick it up a little, Kim. I'm kidding. Kim is awesome. So first, thanks to Mac and Venable for having me. What I'd like to focus on is sort of the mood on Capitol Hill and sort of the threats and opportunities that are being discussed in the policy space at the federal level in terms of Congress. Kim focused on a little bit on privacy in terms of the Hill, but let me sort of set the stage and then I'll drill down to what Congress is talking about. So we're obviously over 100 days into the President Biden's administration. And so I would say that the mood on Capitol Hill is less vitriolic to some extent from the previous administration, but still the acrimony and the long knives are out as the two parties battle over various substantive issues. What makes this challenging is that the margins that the Democrats, who have a majority in both bodies, both the House and Senate, are anorexic. They're razor thin. In the Senate, it is an even tie with Vice President Harris serving as the tiebreaker. So that means, unless you're doing a tax bill, you need to have at least 10 Republicans on board with any proposal to move forward. So in general, as I said, things are acrimonious and very, very tight. There's a lot of back and forth on the tax bill beyond the scope of this call, but just as an indicator, it's that issue is very much very difficult to sort of predict. Shifting over to payments, a couple of thoughts here. One, we see a anti-tech sort of bent in Washington Washington. This is more directed at Facebook, but the tech sector sometimes gets swept up into that sort of anti-tech mode, anti-tech theme. We always see pro-consumer, and we've had a running theme of anti-financial services in Congress since 2008 when the financial crisis hit. So you have anti-tech, pro-consumer, anti-financial services, and payments gets caught up in all of that. Even though the payments industry itself, with the exception of one or two issues, is largely viewed as being helpful, being necessary. I'm not going to say utility by any stretch. We get a little bit of that. We get a little bit of that environment when we think about our issues. The one area that I think is of most importance and of interest to this audience is the topic of cryptocurrencies. Just saying cryptocurrencies or digital assets opens up a whole host of issues. What I'd like to focus on is how they could affect the payments industry specifically, or the policies that are being considered that might affect our industry. And the one that is in play the most is the topic of central bank digital currencies. The central bank is obviously the bank of the particular country. So in our case, it's the Federal Reserve. And they are thinking about, and Congress is thinking about, creating a central bank digital currency. There's a hearing tomorrow in a subcommittee on the Senate, and there's a hearing a week from today on the task force over in the House on this very topic. And ETA will submit comments for the record and a statement for the record. But essentially what this would entail is the Federal Reserve, and there's lots of different variations, but the Federal Reserve setting up a bank account or a payment rail or both to allow it to move the transactions, to move currency. They would replace the dollar with a cryptocurrency, probably a stable coin backed by the US dollar. So practically speaking, not a whole lot of difference. But the risk or the opportunity is that the Federal Reserve is being asked by some to set up bank accounts and or payment rails, which would create both an opportunity and obviously a challenge to the current system. So that is being discussed. There are so many variations here, and nothing has been introduced. The Federal Reserve is moving very slowly. They will release a white paper later this summer. The Boston Fed is working with MIT on a paper. They are working with ETA member companies directly. We are involved with discussions as well to try and shape this. The way ETA thinks about it is that while we welcome innovation, a CBDC, if it's going to happen, must be done right. It must involve a series of steps. We've outlined those steps in our 7 principles to think about how a CBDC could function. One of those, and I'll go through them really quickly just to give you a sense of them, is that it must be innovative. The current payment system is extremely innovative, and any CBDC must continue that trend. The challenge is that when you talk about the Federal Reserve or the federal government, it's very rare that you also use the word innovative. I'm not being critical, it's just simply the way our government works. So any new system would have to be innovative. We also believe that it would have to be interoperable with the current system. The payments industry has built a ubiquitous, reliable, speedy, safe system. Any new system would have to plug into that and work with that system, as well as with the current players. So we think a 2-tiered structure for the CBDC, where the Federal Reserve is here and they push money down to the private sector, who then works to deal directly with consumers rather than the Fed. We think that seems to have the most promise and is a system that we think could work. There also has to be open acceptance. So for any payment system to work, consumers have to accept it, merchants have to accept it. We have that currently with our current system. You can use your credit or debit card anywhere in the world, with most online, with almost every single merchant in the world accepts a credit or debit card. There's exceptions, of course, or a P2P service or / mobile wallet or a gift card. So that system, it works, and we think any CBDC to be successful or even to be considered must have that type of open acceptance. Obviously, we need to have consumer protection. The current system has a great deal of consumer protection, You are not responsible, as you all well know, for any fraud losses that you don't commit or you don't cause. A future system would have to have those same levels of consumer protection, not to mention all the issues that Kim mentioned with cybersecurity, throwing privacy. And we also have to have AML, know your customer, and anti-terrorism financing issues. All of those must be addressed by any system, any new CBD system, and must do it, we would argue, better or at least as good as the current system. And then finally, we need some regulations. So who is going to be eligible to participate in this system? Who's going to be eligible to help? And from ETA's standpoint, and remember, we represent both the traditional sector, such as the banks, payments industry, payment processors, networks, as well as the fintechs, which obviously you all know the names, the PayPal / Venmos of the world, the Wises, the Amazon, the Google, the Apples, although most of the traditional players would consider themselves fintechs as well, which is great. But we need some regulation. And as was alluded to earlier, there's different levels of regulation based on where you sit in the payments industry. If you are a bank, you have one level of regulation. If you are a fintech, you have a different level of regulation. And so we believe that any new system would have to regulate those parties, not exactly the same, because no system, even within the banks, regulates them all the same, but rather based on the risk profile of the participant. So if you are huge and you have lots of different business lines, you should be regulated for that risk. If you're much smaller and only focused on one area, still going to be regulated, but based on that risk profile. So that's an important concept that we think should play into. So all in all, when you take these together, any CBDC should satisfy all of these principles better than the current system, as well as involve members, participants of the current system in order to help be successful. We will watch as this process unfolds. We are weighing in with policymakers to make our views known, to help shape this process so that we get the best result possible that actually ends up helping to strengthen and enhance the current strong system that we already have. A tall order, to be sure, but that is our mission. So Len, I see we're coming down to about 5 minutes. I thought I'd pause if that works for you and see if there are any questions during the final minutes here.
Yeah, please use the Q&A function, folks, if you have questions. I would note, the legislation that I was talking about before that might reinstate or create some of this FTC authority has big impact potentially for the payments industry. If you are concerned and want to get involved, I know Scott is interested in that. And I think one of the big issues is, joint and several liability. So that is of tremendous importance to the industry. So if you have thoughts and would like to get involved, talk to Scott. We can put you in touch with some of our legislative folks who have been trying to work those issues. But it in certain cases, it could be existential for payments companies, given the type of relief the FTC wants in these cases.
Right.
Any questions, folks? We've got a couple minutes. It's pretty well on time. If not, we'll give you 3 minutes back in your day. Don't forget the CLE code is regulatory 2021. Please join us the next 2 days for our other outstanding panels. Thank you all so much for attending. Thank you to the panelists for presenting today. You guys were all great. And I hope everybody has a great week.
Thanks all.
Thank you.
Yeah.
Thanks everybody.
Take care.